Hi, Jeff Mersace here, and today we have Evonne Hopkins of Hopkins Law Firm PC, and she is going to talk to us about some family law issues. So Evonne, tell me, how do you speak to someone if they come in and they say, I want a divorce?
So in North Carolina, in order to get divorced, parties need to be separated for a year and a day. And some people think that they can live in one part of the house and someone can live in another part of the house and they can just agree, okay, we're separate for a year and a day and then we can file for divorce. Well, that's not true. They actually have to physically be separate. They can't live in the same house and be separated. So I prefer, when people come to talk to me about the divorce process, I prefer that they're still in the house living together, and I can then give them as much advice before anybody actually physically separates, because there are ramifications and implications to actually leaving. So if you're if you're the spouse that actually moves out of the house, it's important that you know about criminal trespass, you know about abandonment, you know what your rights are and your obligations are if you're either a dependent spouse or a supporting spouse. So it's really important that we gather all that information and have the ability to guide from the very, very beginning, because if mistakes occur, even in the earliest stages, I then have to do damage control and try to fix those mistakes.
Okay, I guess that's a kind of good lead into the next question. I've been doing estate planning for almost 20 years, and I've seen it all, or at least I've seen it all until the next thing comes up. I'm sure you've seen quite a bit. What are some things that people should never, ever do once they decide they want to get a divorce?
Well, I think some of it are things people should do even before they've actually made the decision. If there's even the inkling that this is a relationship that's not going to work, posting your life story on Facebook or any other social media can be very, very damaging. I mean, that's where us divorce attorneys, the first place we're looking is social media and anything that's posted on the internet. And it'd be astonishing what people actually put on the internet for us to use in court. Even if they don't think it's immediately damaging, I mean, it shows a lot of character. And so if you go up on somebody's website and it has a lot of inappropriate pictures of women in thongs and you're just like, it's going to be used in court. And I've put it up in front of a judge and watched their face kind of scrunch up, and then they're looking at this person who's asking the court for something, and they're judging that person because of the content of what's on Facebook. So even if it's not immediately damaging, it's damaging.
Yeah.
And then I think having an affair is always very damaging and problematic. And causes lots of issues, not only in a alimony case, but also in custody. It can really impact, especially if that affair occurred while they had custody of the children, or the children were in the house, or in some way can damage their relationship with their children.
Okay. All right. How important is it to have an attorney in the divorce process?
Well, a lot of people think that they can do this on their own. And although us attorneys think that we're invaluable and we're necessary in everything, the reality is that what happens a lot of times is people will come to my office having thought that they had entered into a valid agreement, or thought they had worked it out on their own and downloaded stuff off the internet, and they just created a bigger mess. So it costs them more money down the road because they thought they were saving money up front. And again, I have to do damage control, I have to clean it up, I have to fix it. Sometimes they've waived things I can't get back for them, or they gave up rights that they should never have given up. So
can you give us just a few examples of some of those
Sure.
things?
Oftentimes people waive alimony in a separation agreement, not really realizing that they were entitled to it and what that duration would be, and they just completely given it up. And if that agreement's valid, whether or not they were represented, I can't get that back for them unless I'm able somehow to successfully set aside that separation agreement. Or sometimes people give custody, they'll do like a 50-50 custody schedule, they'll give up primary custody, and they are then unhappy with it or said, oh, well, we promised each other that we were going to do a different schedule than what's on the paper. That was just for child support. I hear that all the time. We
Okay.
just said 50-50 so no one would pay child support to each other, but that's not really what's happening. So
Okay.
sometimes it's hard once I have that agreement to then take that agreement and change it. So it's just important they get the proper advice and they're not waiving things that they don't otherwise know about. And then other times that there's just like, so a separation agreement that's under seal has a 10-year statute of limitations. Well, a lot of times they don't do it under seal. So it doesn't have that long statute of limitations. And if someone doesn't do what they're supposed to do, that could be a bar from getting a recovery.
Okay. All right. Well, Evonne, how do people get in touch with you if they need your help?
So we have a website, and it's www.raleighlawfirm.net. We're in North Raleigh at Falls of News, just north of the 540. And my phone number is 919-268-4070.
All right. Well, thank you very much for being here. We're glad to have you.
Thank you.